All right, haters. I am not hating this. I am hating this moment. But anyways, this is Bananas. It's me, Jamie Taylor, with another episode of I Hate Real Estate. Kendel Grims and I are here to talk to you about all the things bananas in real estate.
Like we usually do.
You're not entertained by my antics. I even brought a banana so I could be like, attorney, Kendel. I wanted to eat it, but I'll wait. So this is what we're going to talk about. It was bananas last night. I got a message on my Facebook, one after the other, related to that clip that I posted where I said, oh, it's the top 5 things that affect your property value. And that was kind of a glaze over. We were just talking about with respect to when you get an inspection, what are the top 5 things that could surprise you from a cost or disclosure issue, which I said were, foundation, roof, HVAC, plumbing, electrical. That's where all the surprises are. And that was more related to construction defects. But that being said, the thought comes up, what are the top 5 reasons that you file lawsuits related to real estate? So we'll go through that list real quick. Okay. And now it's Kendl's time to shine. So if you love the law, listen up.
Well, and you asked me before the show what the 5 were. I can probably not regurgitate all 5 of them now.
I know.
But I know the top one is something we've talked about a lot on the show is the lack of disclosure. I mean, that's the number one phone call I get in cases of real estate transactions, whether I take the case or not. And it's the number one reason why we file real estate cases here.
Do the conversations start when you get those calls? Is it more often the agent or is it more often the homeowner or the buyer?
I never talk to the agent on those.
Really?
It's almost always the buyer calling me. But usually it's because the agent has said, call a lawyer or here's Kendl's name, call Kendel.
Yeah, because the squiggly line says you're not allowed to give legal advice as a real estate agent or broker because apparently we have to go to law school and get a law degree to do that. Which
it's kind of funny too because I'll do discovery in cases, which is where we send out requests for documents to the other side, and sometimes they'll do third-party subpoenas to the broker of the agent or the agent for the buyer, and they'll have to produce all their text messages, and I'll get them, and they'll be like a screenshot of my face in one of the messages that says, "Call this guy."
Call this guy.
Okay, so that's how they got to me.
Yeah.
But you see that from time to time. But usually it is the broker or the agent referring the client to
an attorney, right? Well,
sometimes
the best attorney.
We'll get a cold call, and sometimes I'll get a Facebook. Sometimes I don't like Facebook.
You guys are not following him on Facebook. You need to. He'll get all overwhelmed.
Sometimes I get a website contact. We have ways to contact us through the website, email. There's a form you can fill out. But a lot of times I'll get those, and if it's a situation where I can tell that somebody's already talked to 6 other law firms about this and they won't take the case, then it's probably not. But I return all phone calls still, even if it doesn't look like it's
going to be your case.
A good case.
Well, and here's the thing, though. When you talk about disclosure, you immediately, I'm assuming you just dive right into what documents, who was involved, what was the situation? I mean, do you get their analysis on the phone or do you have them come in and talk to you? And then at that case, do you ever look at a case and you're like...
The first thing, generally we talk about what the problem is with the house, right? Just the basic story. The next question that's always asked is, have you gotten quotes to fix what's wrong? Because if this is a $5,000 problem and they're just pissed off because somebody lied to them, there's no reason for me to get involved. If you had to eat $5,000 and make the repair yourself and you never recovered it from the other side, that's a whole lot cheaper than it's going to be. Not even cheaper. The time that it would take you, that it would consume to be involved in a lawsuit that goes after $5,000 is not worth it. And nobody wants to blow $5,000 with no recourse, no action, no benefit from it other than repairing something that they never should have dealt with. But that's a whole lot better than spending way more than $5,000 on attorneys and wasting all that time.
Yeah, I object. I would say that a lot of people's egos get in the way and that you make quite a good living when people get pissed off at each other.
I cannot tell you how many times that someone has said, I don't care what it costs.
I'm going to get my way.
It's on principle. Mm-hmm. And they get our first bill. And we're not like an overwhelmingly expensive law firm or anything, but it takes time to draft things, to draft complaints, to file lawsuits. It takes 5 to 10 hours of work to do it. And they'll get a bill for $3,000, $4,000, $5,000, and they'll call me and go, shut it down, we're done, what do I owe you?
Yep.
And it's all of a sudden not so great of a principal idea.
Well, and that's what I kind of love talking about when it comes to this, no matter what these top 5 are, but starting with the disclosure, it's like, I don't want to pay you to solve my problem. I have to. I'm in a situation where I need your advice and your counsel. But at the end of the day, I want to be protected and make sure that you're going to take care of me. If you tell me as an attorney, hey, probably not in your best interest to pursue this case because it's going to cost you a lot of money. And oh my gosh, the time going back and forth to court, waiting on court hearings, all of that, going somewhere, that's a lot. And it seems like it just carries the deal longer than the deal needs to go.
Well, you made a good point too, though, because in consideration of a plaintiff's case, where a plaintiff has a claim that somebody lied to me on a disclosure, I have damages, is a completely different analysis for me than it is if I get the actual seller who calls me and says, hey, I got a letter from an attorney that says I lied on a seller's disclosure and they are demanding $150,000 or even $5,000. They don't have a choice in the matter. If they get sued or have to respond, it's not a choice at that point in time. They can try to resolve it if they want to, or they can defend themselves if there's no resolution that can be had. But in any event, they have to hire a lawyer. They don't have a choice.
Well, and I love this. This is one of my favorite things about real estate is that it's so analytical. So if it doesn't matter if you're the attorney, the agent, the appraiser, the inspector, like you're looking at this property for a different reason, for a different intended use or a different intended user, all based on that engagement. So the first phone call you get, you're like, okay, whose team am I on? Who's going down? You're already got to formulate a plan. So disclosure or lack of disclosure, number one reason that Kendel gets phone calls for lawsuits. But what about number two? I like this one. I'm surprised by it because I've never sued anybody for commission. And I've never had anybody sue me for commission. So I'm curious, what comes up with commissions related to lawsuits?
Yeah, so I don't know which order they'll be released, but we just talked about this morning on another podcast episode that we recorded. That's why I'm wearing the same outfit. Jamie's professional enough that she goes and changes.
Listen, I'm not professional enough. I post too many things on social media, and you're like doing your job, so you're not on social media worried about if someone saw the same sweatshirt twice.
But we talked about it a little bit because the Arkansas law says that a real estate agent that presents a buyer ready, I can't talk today.
Willy-nilly.
Yeah, it's a willy buyer.
This is what happens when the Razorbacks win and beat number one for the first time since I think they built that court. So pretty amazing. Congrats, Razorbacks. Back to business.
So ready, willing, and able buyer. If you can present a ready, willing, and able buyer, and the fault of closing is at the sole fault of the seller. So the seller then can't produce title, can't produce good title, whatever it may be. Any fault that's the sole fault of the seller that wasn't something that was a contingency in the contract, then you're entitled to your commission under Arkansas law. And I have filed over the years probably a dozen different lawsuits on behalf of real estate agents to go collect a commission.
Okay, I want to talk about the buyer side because that's the awkward one, right? Where if you do terminate an agreement and you had a commission that was going to be paid to you as the agent that was representing the buyer/selling agent on that side of the transaction, if the transaction terminates, you have a right to your commission, but you can't go to the seller for it.
Well, it depends on the
agreement.
It depends on what the documents say and how they're lined out. I have never done it. The situations that we've always been involved in is where someone sent a buyer and they ended up having the listing. So you have kind of a dual agency situation is most commonly where this would come up. You can have it on both sides though. But to say that a listing agent would be entitled to a commission is true. You can have a listing agent and have a buyer's agent that brings a buyer to buy your client's property, and then your client cannot produce good title, you're entitled to a commission from your client. But on the buyer's agent side, it depends on what the documents say, because on the buyer's agent side, if you bring your buyer who's ready, willing, and able, and you make an offer to this seller, and then the seller can't close in a situation where your commission would have been paid by the seller out of closing, it poses a whole
new set of
issue
questions
with the contract, because there's all these privity of contract. Do you have a right as a buyer's agent representing a buyer to collect a commission from the listing agent's client, the seller, because you don't have a contract? You as the agent don't have a contract for a commission or a fee with
from the seller.
But
technically I have, and that's where it comes down to exclusive buyer agency agreement, because my exclusive buyer agency agreement guarantees that I'll be paid by the seller of a transaction unless otherwise indicated through the agreement. So if the buyer agency agreement, hypothetical condition, extraordinary assumption, the buyer agency agreement is executed for the buyer to get paid by the buyer. Like, let's say it's one of these commercial deals where I go in and my buyer's like, I don't care, I'll pay your commission. If the buyer's going to do that and the seller fails to close, the only way to recoup that, because you are a real estate agent and you can't collect fees outside of a closing, would be a lawsuit, right?
So
even if you have an amicable relationship.
That's different from the bringing a ready, willing, and able buyer to a transaction. Because if you bring a buyer to a transaction who can't close the transaction.
But let's say he can and the seller fails to close, cloud on the title.
You don't have that right. Because the buyer hasn't done anything right. The buyer was a ready, willing, and able buyer. Just because they owed you the contingency because they owed you the commission, and this seller couldn't satisfy a non-contingent portion of the contract, then the only cause of action or right that you could even potentially have was that you got damaged by the seller's conduct or inability to close. And that's a tough, no pun intended. That's a tough sell on that seller owes you a commission.
Yeah, I mean, in some conditions,
it's even worse if you have a contract with the buyer saying the buyer's paying your commission no matter what.
Because then you have to sue your own.
If you have a contract where it's in place where the seller is paying the buyer's commission as a part of the contract, it's more likely.
Yeah.
That's the more likely scenario where a buyer's agent with two independent agents, where a buyer's agent could go after the seller as a third-party beneficiary to that contract because he was supposed to pay your commission.
Well, plus, and we'll get to it later because it's one. And you know what? We can actually just move right into it. We're going to switch 5 to 3 here because refusal to close. Like, that's where I'm really thinking about this. So hypothetically, let's just go ahead and come out with it. I had a listing one time where I listed the property and I knew the person. So there wasn't even any weird. I knew this person. So I listed the property and we put it under contract, and then we get right up to closing date. I'm pretty sure I called you about this. We get right up to the closing date and he just disappears, not answering the phone. No one can find him. I can't find him. Nobody can find him. He ended up popping up, but it wasn't at closing. And so his refusal to close, the buyer ended up dropping it. They didn't want to go and proceed and fight with him. They just wanted to find a house in this market and move on. But it was the first time anything crazy like that had really happened to me. It was I think probably the weekend I created I Hate Real Estate was probably on the back of that deal. But when he refused to close that, I was damaged as the agent because not only did I not get my listing commission, that buyer's agent didn't get hers, and she did everything she was supposed to. And that's why some of this is a question for me is what happens when you can't do anything as an agent to force somebody to engage in a behavior that they have contractually obligated themselves to perform? Where's my recourse?
Yeah, and that's an interesting point too, because I can envision in that scenario where if a listing agent then says, it's your fault for not closing, I'm entitled to a commission, but you had a buyer's agent there as well.
She was nice.
So let's say your exclusive listing agreement says that you're entitled to 6%. But like I do, that when a buyer's agent brings a buyer, there's a split commission on the deal. Mm-hmm. What if that listing agent sues for the full 6%, to which they wouldn't have been entitled had this person closed? Does the buyer's agent have a right to step in and intervene in the case and try to collect the 2.4% that the buyer's agent would be owed?
Well, in my idealistic mind, and this is kind of now what I'm thinking, maybe you should take this case, is maybe the buyer's agent and I should have gone in toe-to-toe to the seller and been like, look, we did everything. Buyers did everything. You have to close this, and if you don't, we're going to sue you.
That's a different lawsuit, and that's more along the lines of the failure to close.
Yeah,
the third topic.
But now I see why you say they're so close together, because failure to close really is one of the main ways to get your commission.
The agent's actions are for the commission. The agent has no cause of action for specific performance, which is what the failure to close is. A specific performance action is the failure to close, and I get calls on these all the time. Most of the time, it only results in a letter that we write, and we'll write a letter, and we'll get a call and say, yeah, after you wrote that letter, they showed up and closed this deal.
Do they do that because you send them a letter about the specifics, and then they perform?
And we basically tell them, here's what all is fixing to happen if you don't close this deal. Yeah, and they show up and perform. But we filed specific performance lawsuits as well because Arkansas views every piece of real property as unique. Even if it's vacant land,
every real property is unique.
It is unique. And so each property transaction is a unique opportunity for a buyer to buy that property and a seller to sell that property to a buyer that's unlike any other transaction. Even if it's identical in terms, monetary, just different locations, it's still different because that property could have a different purpose.
For the record, every property is individual. So when somebody, I don't know, like Zillow tells you that they can use antiquated data to value property over time, they're wrong. Okay, moving on.
So it's all unique. Arkansas views it as unique. And so specific performance says since you have a unique piece of property, the only remedy that can be obtained to give you the proper compensation for the damages you sustained by not being able to buy the property is to actually force somebody to close.
Yeah.
And if a court issues a judgment or an order saying you have to go sign those closing documents and they won't, we have a rule in Arkansas. It's a civil procedure rule.
You're going to say contempt.
It's not even a squiggly line. It's actually more interesting than that. I think it's rule 70. I can't remember now. It's either 60 or 70. It's one of the round number rules.
I'll make you a note.
Yeah. And it actually says that the court has the ability to appoint a third party to sign the document on your behalf at closing. And it's a court, and the court can do it. So if the court orders any act to be taken and someone refuses to take that act, the court can appoint a third party to take that act on the person's behalf that they ordered to do it, even though they won't. Now, there's probably contempt in there also for violation of a court order, but your objective in this deal is not always to punish somebody. It's to get
them in cuffs if I have to, down to the courthouse to sign the document so I can collect my commission. But it comes down to, as an agent on the front end, you can do everything right.
Yeah, they won't cuff anybody.
Oh, well, whatever, in my dreams. You literally, and here's the thing, though. I
actually
don't want that.
The court will order the agent. The court will order an agent that was representing that client to sign all the documents.
Which would have been fine, because here's the thing, and that's what it comes down to, is like what shocks and appalls me about something like commissions and refusal to close being lawsuit items is that you can do everything as an agent and be totally professional and perform specifically on every task, and your seller can refuse to show up, and there's nothing you can really do about it besides taking on the costly involvement of a lawsuit, getting your attorney and then going through this and trying to figure out from every analytical standpoint, and you have a whole team of people who are arguing their side on the other side. It's just so much, and that's why what did I do? I mean, what I did was I go, darn it, and I told the other agent I was so sorry and I was very embarrassed. And then that was it. I issued a termination that never got signed and moved on with my life. So commissions and refusal to close are something you can sue somebody on, but I can tell you from experience, it's not worth it. Just walk away.
Sometimes a commission can be worth it.
Well, it depends. If it's like a $10,000 commission,
so if you have a really I know I say every piece of property is unique, but if you have a 1 acre piece of blank ground in the middle of nowhere, it's not necessarily unique, because you can find a 1 acre piece of ground in the middle of nowhere.
Well, there's acre plots lined up next to each other in Arkansas. So.
Exactly. Yeah, they're all over the place. So, but if it's some house on 13 acres in Podunk, Arkansas, that you're not going to find this kind of construction in that town, and your job is in that town, then specific performance can be a more of a beneficial option to you.
Well,
but on the commission side, let me give you a case that we did.
Ooh, I love
on
it
the
when
commission
you do
side. So we did a case on the commission side where this is the common scenario, where we had a listing agent who listed a piece of farmland up by Searcy, Arkansas. It's in northeast Arkansas, kind of. It's in between. It's kind of north central east Arkansas. Yeah. And they had a piece of property, some farm acreage there, and it was tied up where someone had died, and it was supposedly in a partnership. Well, there was no partnership, because it turned out it was only one owner, and you can't have a partnership with one person. It has to be 2 or more persons by law.
We're going to sublease this.
So
it
ended up having this person died. So we had to go do a full background search, find all these relatives and everything else that would have inherited the property. Well, on the front end, the listing agent signed up the person from the family who was the representative of kind of everybody.
Is a realtor.
This is a realtor. No, the realtor finds one of the heirs and says, sign this up, let's sell this property.
Okay.
And we're going to get everything in order. Well, it turns out that at the time they execute it, this person who was the family representative had talked to a local attorney there, and they had discussed all these options of needing to quiet title, all the probate issues. None of this is disclosed to the listing agent. So the listing agent has the property listed. I mean, this is a large commission on farmland, and has it lined up. They go find a buyer, bring the buyer in. The buyer makes an offer, all the stuff. The buyer has separate counsel, and so they're going back and forth talking about it. And ultimately, the closing date comes and goes because the seller can't produce title to the property. The title company will not issue
which he knew going into it, right?
And they knew going into it and didn't disclose it to my client. And so we actually do discovery, and we get the emails back and forth between these two lawyers. And sure enough, they're also discussing, and they say in the email, so we don't have to pay a commission, can we agree that we're terminating this contract mutually and not because we can't produce good title? And so we end up getting all this communication about it where they're essentially hosing our client, and the judge was not very happy about it and ended up I can't remember if he struck an answer. There was some kind of sanction for the conduct, and ended up entering default judgment, gave us all of our attorney's fees and everything else, and we collected. And then when the family found out about it, the family was out in California. The representative lived in Michigan. All the other family members found out in California. When we slapped a lien on the property of the judgment that we obtained, it was a 6-figure judgment. We got a phone call a few months later saying, hey, now we've got this cleaned up and we're trying to sell it again, but you've got your judgment out there. Can we negotiate this? And we said, nope, you owe us every penny of it back because we expended a lot of time, energy, and resources on it, and they wrote us a check.
Well,
they
you know
collectively pulled together the money and wrote us a check and then went, because the property was worth a mid-7-figure number.
Well, here's the deal about that. Thank you, and good job. But here's the thing about, that's what I love about you guys, too. Your team is crazy good at discovery. I think that's where a lot of your preparation and knowing something, going into something is really impressive. But yeah, that makes me happy because why would you lie to a real estate agent like that? And here's the thing that sucks about it. They're not coming out there I mean, yeah, I talk about sometimes there are agents out there who just do it for the money. But even if they're just doing it for the money, they did their job. You know what I mean? And they did it well. And the other part is like you're just bold-faced lying to somebody and you're creating an opportunity for them to lose their ability to do their job. I mean, like we've talked about on the show, anyone can sue you. What if the agent got called in somehow?
I mean, this agency spent like $25,000 marketing, advertising the property, all kind of, I mean, it's large dollar amounts in the farm transactions, especially with the price of farmland these days.
Don't lie to your agents.
And your listing agreement says they sign off that they're not going to lie to you.
Not only that, but they agree to pay us a certain amount. There's even a post-closing and a cancellation fee. There's all kind of things. If you're not going to do what you say, don't sign the contract. Or you're going to end up in Kendel's office.
There's a whole. We did another one. I know we're on limited time, but we did another one.
Never. We're not on limited time. It's when we have guests, we have to pay attention to their schedules.
We did another one where we may have talked about this one on the show too. I don't remember, but we did another one. It's a shorter story where the agency had a listing agreement, and they have an expiration date on it.
Yeah,
and they start talking about renewing. The agency says, "Hey, we're still marketing this. We're getting a lot of contacts. We just haven't gotten any offers yet. Can we renew this for another 6 months?" And the guy's really flaky about renewing it. Won't really commit to renewing it. Anything else? The renewal period, the expiration period comes and goes, and the contract expires, and they find out that the day after he enters into a contract with someone else to sell the property, and they claim that the person that had contact had nothing to do, that our agent had nothing to do with that person reaching out and making contact. It was a completely different deal that actually happened 2 months ago during the listing period. They didn't tell their client. The client found out that the contract even existed by trying to have this conversation, and he overheard the wife saying, "Have you told him about the other contract that you signed?" Yeah, I mean, it's just this wild deal that they went through. So we ended up saying, we're going to sue you, and we settled that one without a lawsuit. Because there's just no way. And what happened was this client did a really good job of it's farmland again. Different client, more farmland. They did a good job where they actually took advertising materials of the property. They used the assessor's website, and they identified every property owner, every major farmland property owner in the 2 counties adjacent, because this property was really close to a county line, in the 2 properties or counties, the one where the property was and the one adjacent, and they blanket mailed out over 30,000 mailers of this thing to all of these people. And the person who bought its name is on the list that they put together and said, we sent them a flyer at the beginning of all this. You can't claim that our efforts didn't lead them to you in one way or another.
Yeah, which that brings up procuring cause, which I'm sure is another one that probably comes across your desk quite a bit.
That's commission deal as well, yeah.
You know what?
But anyways, those are 2 that we've dealt with recently that are interesting on this, and you have it right. Now, both of those are the listing agent scenario. I would love to get a buyer's agent client that has a potential claim and see what we could do legally to try to push that through. But it would need to be one where the risk was worth it. It doesn't need to be like a $10,000 commission or something. It needs to be a big commission.
Well, you have been wronged on the buyer side to a tune of $1 million or so. Holler at my friend Kendel. But here's the thing that's great. When you were talking about that first deal, I literally said we need to have a subsection of this show called I Hate Probate, because I hate probate too so much. And that's like, between probate, procuring cause, all these commissions, this is actually how the show was born, talking about these things. So, okay, moving past those, that's 3. We've talked about disclosure or lack thereof, commission, suing, and then refusal to close, which kind of falls right next door to commissions. Typically happens with a buyer and seller, right? Nobody else is going to refuse to close the transaction. Yeah. So the other one, we'll just go right into this. I hate it, but we'll just cover it lightly.
We've already talked about how much
we've already talked about it on the show. I hate earnest money.
Yeah. I've had more pissing matches over earnest money than you can possibly imagine. I mean, people fight. You'll have a $5,000 earnest money contract, and there'll be a huge fight at the time of termination over who's getting the earnest money because we have this mutual termination requirement, and somebody else hold the earnest money over somebody else's head if I'm not signing this termination without it being my earnest money. And the mutual termination references who's supposed to get the earnest money back if there is anything, and it's
we just talked about this the other day because I called you on the phone. And so, public service announcement for real estate agents. Here's the thing about that. The earnest money is going back to the person who submitted it almost 100% of the time. The paperwork literally says that. And then it also says...
Just don't use
it. Sorry, don't use it. Don't use earnest money. It's
That's
stupid.
The easiest way to avoid this. It's just don't
here,
use
I'm going to
earnest
give you
money.
this banana. Okay,
Because
I'm going to give you this banana. And at the end of this episode, I'm going to need you to either keep the banana or give the banana back, depending on how this goes.
Yeah,
okay?
It's exactly what it is.
All right.
And it
We'll see where
used
this
to be
banana
a
goes.
theory that somebody came up with that a contract had to have consideration at the front end. Thus, the earnest money had to be put up for some kind of insurance that certain things were going to be done and to cover the consideration under the contract. And it's just...
A lot of people say to me that, well, it shows me that they're serious when the buyer's agent brings earnest money. And my response to the seller is like, okay, well, let me tell you this. Having them come out of pocket for that just so that you can make sure they have it doesn't make any sense. They have all this other stuff they need to do on their financial end to get their lending in order. I don't care what price range you're in. If you can't get it back without an expensive lawsuit, what is the point of submitting it? Sorry.
It's really pointless.
You need me to...
No, to me, it's really pointless. It doesn't have there's no legal requirement to have it.
It's just a fight.
There's no legal requirement to have a non-refundable deposit if you don't have earnest money. There's no legal requirement to have earnest money if you don't have a non-refundable deposit.
And there's more paperwork.
It just causes headaches. It causes headaches for the title company. I guarantee you that American Abstract is holding some six-figure number of earnest money in their escrow account that's been there for more than 90 days, probably more than 6 months, because they've had transactions that didn't close and nobody can agree on
who gets the earnest money. It's like herding cats.
And so then what happens is the earnest money, the title company has to take the earnest money and do what's called an interpleader lawsuit, and they have to file an interpleader complaint as the plaintiff. The title company does.
Do you see?
And then they have to name the parties that could possibly be entitled to the money as defendants in that case. They have to get an order from the court that says the court will accept this money into the registry of the court, and these two defendants that we've sued can fight over who gets it, and the court will decide who gets the money. And on top of that, let's say you got $5,000 in earnest money. The title company's attorney that files this case is entitled to reasonable compensation and the reimbursement of all expenses out of the earnest money for filing the interpleader case under the law. So you're already going to knock off another $1,000 to $1,500 in attorney fees and costs for them to file this interpleader lawsuit that you're not going to get. So now you're fighting over $3,500.
Yeah. So I literally in my mind was just like, earnest money, creating jobs in Arkansas since 1902. Like seriously, what is it's like? All of those steps have to be taken because of earnest money, and you probably can't get it back. So anyways, don't do earnest money. Just don't do it. That's how we feel. Then moving on, this is going to be the last one in the top 5. And so we covered top 5. Like we said, there's like property aspects, but then there's also these legal things, which are what you're most commonly filing casing over. And I really love this one. We're going to have a contractor on the show upcoming, which is actually great too, because she's a female contractor and she's really smart. And one of the things that's amazing.
What company is she with?
I'm not telling you till she comes.
Well, I might have sued her.
We'll
talk about it after the show.
She's never been sued, so
okay, well,
I did. I showed her the show, and she's like, "Oh my gosh, this is so cool." But when you guys meet, it'll be great. The point is, if a contractor can be pulled into a lot of these ones, because what we're going to talk about is construction defects, and that could also be builder, surveyor. I'm assuming, right? Tell me what construction defects, with respect to lawsuits, even means.
Yeah, usually it's something that the contractor did on a construction defect side. This also goes hand in hand with the non-disclosure issue, because if you're buying a home that the homeowner that's there was actually involved in the building of that home, or a business, it can be a commercial building, then they may have some knowledge about something that existed during construction that was supposedly cured by the contractor, and they won't disclose it. So that's one construction defect case that we've tried. We've actually had multiple jury trials on those contractor cases. But a contractor case can be in a new construction, it can be in a remodel.
It can be in a repair.
Any repair. It can be in any other scenario where you have a construction defect. And we get a lot of these.
What to say?
Surprisingly. I mean...
Is it mostly... I would think it would mostly be resales where the seller said something was done, but this is just what my
That's
experience
a disclosure issue.
It's disclosure, but it's also they find the defect in the inspection. And that's normally what kills the deal, because it becomes whether or not you can afford to purchase this property with respect to that repair.
So there's a limited scenario where you can have an action against both the person that owns the home that's selling it and the contractor that built the home, if it's a scenario where they build a home and it's been there like 2 years and they decide to sell it for some reason, you could have an issue where there were still existing warranties that had been given by the contractor or defects that the contractor knew about that weren't disclosed to the homeowner or that didn't pop up any inspection. Like I've had cases where I've sued both the contractor and the homeowner.
Okay, that's a great point. And like, this is really actually a great point. And I have a question because this just happened. And I think you did a deed for me in this deal. We had a client where a property had been encroached. But when the person bought the property to flip the property, they didn't get a survey against my advice. Point is, they didn't get a survey.
That's another one, always get a survey.
I know. Maurice Taylor loves to say that. He's got some really great notes about
because if you get a title policy, it's going to have all kinds of exclusions in it if you don't have a survey. And if you don't get the survey and you have those exclusions from your title insurance policy, you may as well not have title insurance.
Well, but here's the other thing about it is that you don't get a survey, do what these people did. They expanded the property. You know, they built onto it. And when they built onto it, they crossed the property line. And when they crossed the property line, we didn't find this out until what happened is a buyer came to me and said, hey, buyer and buyer's agent, hey, we're really interested in this property. Do you have a survey? And I was like, listen, don't buy this property without a survey because I know they don't have one. I told them to get one. There needs to be one. Put it in the contract. If they're willing to do it, let's do it. So sure enough, we get the survey, and then we get the terrible news 3 days before, because surveys are running late right now, that it was in that situation. And so I'm sitting here going, okay, what do we do? And of course, I mean, when you have someone as experienced and hardworking as I am, we worked it out, and you did the quitclaim deed, and we talked to the neighbor, and everything worked out. But could the contractor be held liable if, like, for any reason in that situation, or would he have to say, okay, I had reasonable reason to believe that I was modifying this property on property that they owned. There was no way I could have known that it was encroaching on the property line. But if that neighbor decides to sue somebody, could they sue the contractor and the homeowner for encroaching on the property?
Potentially, yeah. I could envision a scenario.
And they'd have a case.
I could envision a scenario where you could file a civil trespass case against the contractor.
Adversary possession, if you don't see, or adversary possession.
Adverse possession, yeah.
What is it going on around here? This is bananas.
It is.
Also, just so you know, this banana still belongs to me, but you can hold the banana. Okay. And then if we finish the podcast and everything goes okay, I'm going to probably give you the banana back. But if it's not good and I decide I don't want to be part of the podcast for the rest of the episode, I'm going to take the banana. Yeah. This is my Earnest banana. All right, moving on. So, construction defects. I'm making a very simple example, okay? If there might be a new agent out there that doesn't know how bananas earnest money is. So, moving on.
But there's other potential things there with the building over the line. I mean, a survey obviously would have solved all those problems, and they would have known. The homeowner certainly has caused some kind of trespass on property. And
encroachment.
In theory, the property owner over which it was encroached could have walked up with a sledgehammer, and everything that was on their property, they could have torn it down. That's a real good way to get into a lawsuit real fast, but in theory, they can.
Well, the other part of it is, and this is the part that really, really lets my brain start going wrapping around circles when I get that phone call, is I get that phone call and my immediate thought is, okay, like, sorry, buyer, that this isn't going to work out. But then my next immediate thought is, because I'm in the interest of the seller, and I knew that there were going to be 40 thoughts that came when I got that phone call. But the first one was, oh man, they definitely didn't know. They wouldn't have invested their money in this to do it. Why didn't they get the survey? I wish I had met them before. Well, but then also, this is really what got me, and nobody mentioned it the whole time. Nobody thought about, like, next door neighbor has interest in the property. Next door neighbor owns a piece of the property. Next door neighbor can value the property and get a percentage of the property paid to them. You could also buy the piece of their property that they own, but they could go two directions with that. And I think most people will be like, how do I solve the problem, get through the deal? I was like, oh gosh, I hope no one says anything about this and I did disclose it. I told them, I said, this is what's possible. They could come and try to buy part of your house. But that's true, right? I mean, they become a property owner at that point.
Yeah, they own the improvements that are on their property.
And they would have to actually do a lawsuit.
There would be dispute as to ownership, but in theory, that has become a fixture on their property once the houses or any kind of construction was built there.
Well, and any property that sits on your land that holds value, you can look at that and see what your percentage. They don't have a right
to modify it without trespassing or having to get permission.
And it all comes down to one very simple thing that needed to be done on the front end.
You could even make a property damage claim because you had let's say it's a yard.
This
you
is
had
fun.
A yard,
see, this is why I like talking to you.
Somebody built something on your yard that damaged that property. In theory, even though it may have made it more valuable, it caused damage to what was there beforehand.
Yeah, and that reminded me when she said earlier too, when Ross said, if these pictures are, we were recording another episode, and Ross said, if these pictures are real, I'll come over and make an offer. And I thought to myself, well, that reminds me of Chris, which reminds me of the survey, which reminds me of the house on the other piece of land. And it's just kind of amazing the as the weeks go by and we engage more and more people in our market to participate in the show. It's like these things are going on every single day, and we've all got experience with them. So the more we can bring them to light, the more we can talk about them, the more fun we can have, and the more problems we can solve together.
You also, from a contractor standpoint, there's setback requirements in almost every city, unless this was out in the country somewhere outside of city limits. But it was?
Yes.
Oh, so there were no setback lines?
Well, no. And where else are you going to go next door and ask if you can have a few acres? I mean, that doesn't happen in the city.
I just, a contractor should know better, though. If they
Except
were in
Highway
a city,
10.
if they were in a city with setback lines, Well, a lot of Markham here in Little Rock was screwed up with the survey years ago when they did it, and so a lot of people's properties that are actually surveyed are like inches off, and as it goes further down Markham, you get feet off, and they've been trying to do quiet titles over there for decades.
It's amazing to me that you just said that too, because if you have not noticed, residents of our great state, which if they drive, they have so much truck construction work going on right now on every single freeway and highway, which to me is like my brain. I sometimes get so frustrated with it because I'm just trying to drive down the road to pick my kids up, and I'm like, ooh, eminent domain. Ooh, look at that. They're going to buy that property and they're going to put a highway there. And so it's really kind of interesting, all of the problems that can come up with property lines when you don't have a good survey or you're not aware of actually what you're supposed to be doing, building, or messing with on a piece of property. So
we just got done with a big,
I know,
eminent domain case.
I want to talk about that case so bad,
Cantrell,
but we're not ready.
No.
That's its own episode. I've literally had like 15 topics for episodes, and I've added like 30 since we've been recording today. And that's the thing. So
we're going to be around for a while.
We are going to be around for a while. But here's the thing about I Hate Real Estate. You guys who are tuning into our episodes, Kendel and I are both obviously badasses in our respective industries, and himself and I are going to continue to produce this show. So we want you to hit subscribe on the YouTube button and follow on iTunes, but also keep an eye on Facebook and what's going on with us here. And if you have questions, a case, a deal that pops up that you want us to analyze, talk about, or just, get bananas on, we will do that. So reach out to us and send us a message on Facebook or YouTube if you want us to cover your case. So do you have anything else you want to talk about today, my good sir?
I'm good.
Okay, since everything went well, I'm going to go ahead and give you this banana.
All right.
Since you earnestly earned it.
That we did a good job in earnest.
In earnest. We did a good job in earnest. But listen here. I am so proud of the Arkansas Razorbacks. We're going to go honorary woo pig suey. If you didn't know, we beat number one because we are number one. And if you want to move to Central Arkansas, call me. If someone screws you in that process, we'll call Kendel.
Sounds awesome.
I'm Jamie Taylor, and this is Kendel Grooms. We hate real estate, and we'll see you next week.